you represent?
I'm here representing the plaintiff, LF NOLL. I want you to just have a seat right there. And actually, we're doing this as a professional. It should go on the record, please, that the plaintiff is really represented by Jessica NOLL at the Deck Law Firm in Sioux City. But as a professional courtesy, she asked us to appear to save her the trip down because she has a conflict, and that's why I'm here.
And your witness is?
Tom NOLL, Vice President of LF NOLL in Sioux City.
And you are?
I'm Melissa ISDER.
How's your last name?
ISDER?
ISDER.
Yeah.
All right, this is Sac County SCSC 015580. Whoops. Caption, LF NOLL Inc. Plaintiff versus Melissa A. BAUER, NKA, Melissa A. ISDER. The record should reflect that is that the right case? I got two computers going here. So. So do I understand, Mr. Becker, that the matter that's before the court today is for extension of the judgment beyond the 20-year period? Is that correct?
That is correct, Your Honor.
So it seems to me that kind of the fighting issue, and I think this is the first time I've ever had one of these come before me, but it would seem to me that the fighting issue of the case is what diligent effort has been made up to this point in time to collect the judgment within the 20-year period, because I think the extension beyond the 20 years is somewhat of an extraordinary remedy. So I guess just for purposes of the record, the plaintiff in this case is represented at this time by attorney Bruce Becker, who is acting kind of as substitute counsel for Jessica NOLL, who could not be present today. And the defendant is present and is appearing pro se. So, Mr. Becker, you may call your first witness.
Thank you. Why don't we call Tom NOLL to the stand?
Come forward, raise your right hand. As far as the testimony you're about to give in this case will be the truth under penalty of perjury. Take the witness. Stan?
Your Honor, before I ask Tom some questions, does the court have a copy in its file of the original judgment against the defendant?
It was entered in Ida County, was it not?
Correct, that is correct, and it was entered on November 7th of 1995, based upon a petition that was filed on July 14th of 1995. I didn't know whether that got attached to the plaintiff's petition, and if so, I would just ask the court to take judicial notice of it, otherwise I'll introduce it through my witness.
I do not see a copy here.
I can introduce it then through my
All right, that's
witness,
fine.
and that way you'll have a paper
Sure.
copy. All right. Tom, tell the judge your full name, please,
Thomas L. Knoll
and where do you work?
at LF Knoll Inc. in Sioux City, Iowa.
And do you have a title at that?
I'm the vice president of the company.
As the vice president, are you familiar with the books and records of LF Knoll Inc.?
I am.
And do you look over those records in the regular course of business?
I do.
In looking over those records in your regular course of business, are you familiar with the name of Melissa A. Bauer, who also may be known as Melissa A. ISDER?
I am.
And what is the position of your company as it relates to that individual?
We have a judgment against her that we are trying to collect.
Was that judgment entered in Ida County?
It was.
And was it entered on November 7th of 1995?
It was.
And you're asking that the court continue that judgment beyond the 20-year statutory period?
Correct.
All right. I hand you, you want me to use A, B, 1,
One.
plaintiff's 1? I hand you what's been marked plaintiff's exhibit number 1, Tom. Can you identify that document for me, please?
That is a copy of the original judgment that was entered in 1995.
All right. We
There
are
are some stickers if you want to use. Easier for me to find
the plaintiff's exhibit 1, yeah.
any objection to one. Okay, exhibit one is received.
Can you tell the court what that judgment was based upon?
It was based on a claim that was assigned to us from the Marion Health Center. I believe it was a result of an accident.
And as I understand it, that you were told at the time by the plaintiff's attorney, Mr. Hamilton, that money would come from the settlement,
Correct.
but you've never received any money.
No, we
All
haven't.
right? And have you attempted to collect the judgment since that time?
We have.
And what are the results of your efforts?
We have not been unsuccessful.
You have been unsuccessful. All right. Tell the judge, if you would, the remaining balance on the judgment based upon the books and records at your company.
Principal, $3,138.92. $6,179 in interest. $219.94 in court costs.
Your Honor, have you received by email a plaintiff's written argument to the court
It was filed with the court, with the clerk. Yeah.
authored by Jessica Knoll?
Yes.
You do have that.
I do.
I'd ask the court to take judicial notice of that. That sets forth the position of the plaintiff.
I mean, it's not evidence of the case, but the equivalent of a brief.
I understand. As long as the court has it, that's what I want to see.
But again, Mr. Becker, what I want to know is what efforts were made to collect this judgment, because again, I consider this to be, a request for extraordinary relief, because ordinarily 20 years should be enough time to collect a judgment if diligent efforts are being made.
And Tom, go ahead and answer that. Answer the judge, if you would, please. What has been done? And
We've tried to collect it. The defendant moved out of state, according to our records, he lived in Nebraska. We registered the judgment in Nebraska, ordered an execution, tried to do a garnishment, and were unsuccessful. Throughout the time, there were several things that we did to try to obtain a place of employment or some form of an asset that we could execute on and were unsuccessful. The 20 years was.
Did you ever do a debtor's exam?
We did not.
It seems to me that that's kind of a minimal requirement that should be done if you're being diligent in trying to collect a debt. I mean, ordinarily, once that execution is returned unsatisfied, you know, that's the next step, if you know where the defendant is.
Have you had difficulties in locating her
Yes.
throughout the 20 years? Explain to the court and for the record those difficulties.
It appeared that she moved around a lot. All of our records indicated to us that she was not employed. Normally, as a course of our business, if they're not employed, we do not go forth with the expense of a debtor's exam.
When was it that you first discovered that she resided in Early, Iowa?
I don't have records of that.
All right.
Shortly before this action, we did speak with the defendant. She wanted to settle it for a certain amount. I don't have that amount with me. We declined the settlement, and that's why we filed this action.
And it was just recently you discovered that in fact she may own real estate and have assets to satisfy the judgment. That's why you're pursuing it now.
Correct.
And those assets and real estate, at least the information for that was unavailable to you prior to filing this action.
Correct.
And I guess the other question that I would ask is, in order to, make a proper record, maybe she should be making a record, that, as I understand it, you contacted the Hamilton law firm at about the time this, apparently there was an action for monetary damages. Did you file a lien on any settlement that might have been obtained in that action?
We did not file a lien. Mr. Hamilton had indicated to us that he would pay us once proceeds were received.
Do you know whether proceeds were ever received?
I do not.
And you haven't followed up there to, I understand ordinarily you take an attorney's word, but there is a method to make sure you get paid, and that is you file a lien.
That's why we had filed this action. Mr. Hamilton filed an appearance on the first action, and he did not appear at the trial.
And let me follow up also. By the time you received this, by the time you acquired the debt from the hospital, it could very well be that the case had been settled. Is that true or not?
It's possible. We would have no knowledge.
And it would be the hospital that would file the lien on any kind of settlement proceeds rather than the debt collector who subsequently purchased that from the hospital. Is that a fair statement?
Correct.
Well, I just understood you to say that your company contacted the Hamilton law firm. They were given assurance that this was going to be paid from any settlement or award. So that would be kind of contrary to what you're just saying now. I just want to have a clear understanding of, whether you had your judgment and contacted the Hamilton law firm and were given that assurance. Is that something your company did?
I don't have records of whether he contacted us or we contacted him.
But there was some assurance. Maybe you should be suing the Hamilton law firm. I don't know. But it's, anyway, I really need to take a look at the law a little bit on this thing because, as I said, I think this is a fairly extraordinary remedy that's being asked for here. Ma'am, do you have any questions for the witness?
I mean, I know I have moved around an awful lot, but I have also been in Early, Iowa since 2006. So there was no reason not to be able to get a hold of me there. I lived in Omaha, Nebraska from the year 2000 until 2005.
You're testifying, so I'll let you testify here in a minute. If you want to ask him questions about what efforts he made or whatever, you can ask those questions. If you don't have questions, then we'll let him step down and you'll have an opportunity to take the stand and present your side of the story.
Okay. What is your obligation in order to contact somebody for a debt? How many times do you contact them?
There's no set standard.
So it could go 5 years before you contact someone again.
If we do not know where someone's at, it could go that long.
Okay. Because you would think with an amount of a debt that much, you would at least try to contact maybe once a month, maybe once every 6 months or something, just to kind of get it.
There are constant things that we do on the accounts to try to locate addresses.
Okay. So do you have record of that then?
No, I do not.
Okay.
Anything further?
No, Your Honor.
All right, you may step down. Additional evidence on behalf of the plaintiff.
Nothing further, Your Honor.
Ma'am, do you wish to testify?
Yes.
Come forward, raise your right hand. Swear the testimony you're about to give in this case will be the truth under penalty of perjury. Take the witness stand, identify yourself for the record. You know, rather than, I'm going to try to keep you on point here, so I'm going to ask you some questions. So it's my understanding that the bill at the Marion Health Center arose from some sort of accident that you were involved in, is that correct? It was a car accident, or what was it?
It was a car accident?
And you retained the Hamilton Law Firm to represent you in regard to your injuries?
Yes.
What happened with respect to that claim?
It was settled out of court, and I don't even remember for sure how much it actually was.
Approximately how much?
Approximately, I think it was like $13,000.
Okay. And I'm assuming that Hamilton's what, they get a third, or?
Well, that was my cut after what they had taken, so I don't know what the full amount was for sure.
And had this judgment been entered before or after the case was settled?
I honestly don't remember.
When did you move to Nebraska?
1999.
And where did you live?
It was in West Omaha.
Yeah, were you working?
Not at that first because I was finishing my bachelor's degree.
So were you married or single at that time?
I was married, but to the ex-husband, yeah.
Okay. And so you were finishing school, he was supporting the family, is that the way it worked?
No. I was supporting myself on college loans and was settled with money.
Okay. And then when did you go to work?
2001, I think.
And where did you work?
At Zeitner and Sons Incorporated in Omaha.
Is that a trucking company?
Correct.
What was your job?
I was a billing clerk
How long did you work there?
until July of 2005.
And were you ever contacted during that 4-year period by the plaintiff?
No.
Were you ever brought in for a debtor's exam in which inquiry was made about what assets you had, what your employment was, and that sort of thing? All right, when did you move back to Iowa?
September of 2005.
And since then, have you worked?
Yes.
And where?
I worked at the Howard Center Incorporated here in Sac City.
And again, was any attempt made to levy on wages or do anything to collect this debt?
Not that I am aware of.
And so when were you then contacted by the plaintiff about the debt?
Just lately, it was, I think it was like 2 months ago. Could have been 3, I'm not for sure.
You know, and I'm not going to get into any offers of compromise or anything like that, but since then, Has there been any, are you working at Hart Center now, or no?
I haven't worked there since 2010.
And where do you work today?
I'm currently taking care of my ill mother.
So you are not working now?
Correct.
And have you not worked since 2010?
I worked at Lutheran Services in Iowa, and I worked there from 2011 until 2014.
So Lutheran Social Services,
Lutheran Services of Iowa.
and doing what?
I was a FSRP worker. I took care of children that were removed from the homes because of substance abuse that were in foster care.
So you, what, monitored them?
Yes.
You didn't have them in your home as
No,
foster
I
children?
just monitored to make sure that they were safe and did supervised visits.
Anything else you want to say?
I know this judgment was also, it was against me, but I was also legally married at the time that the judgment was put in with my ex-husband. And no contact was even ever made for him. But yet, there was a lot of bills that had come forward during our divorce time, and they couldn't find him, so they found me, and I was the one that was responsible for all these other debts. So I'm just wondering why there wasn't any contact made for my ex-husband at the time.
I mean, that, I really don't think that enters into the picture as far as my decision. But, you know, the bills were for you, is that right?
Right.
Health Center. Mr. Becker, any questions for this witness?
Just a few, thank you. Melissa, you acknowledged that you did receive goods and services from Marion Health Center after that accident.
Yes,
And you knew that the total of those goods and services came to $3,138.
they came to more than that, actually, because I was making payments to Mercy.
All right? But you knew that there was an outstanding balance of $3,138 because actually you were sued for that in Ida County.
Correct.
All right? What efforts did you make after the judgment was entered against you in Ida County to make payments to LF NOLL?
At this time, my ex-husband and I were going through a divorce in 1999, and it took until 2002 to get divorced from him. There was a lot of things in the home that I was not able to get because of the contact with him, and I was not able to get any of my bills whatsoever out of the household. He was very abusive at the time, so I just let it go, and that is why I moved around so much, is because I didn't want him to actually find me, and when he did find me, I would leave again. So I was not able to get any reference to anything, actually.
So if your intent was to move around from your husband to keep your presence known from him,
He found
then-
me.
Pardon me?
He found me.
But LF NOLL then is in the same predicament. They can't find you.
They could, if they looked hard enough, they could have found me, because I was stationary in the same location and the same job for 5 years, especially when the one for Douglas County, I lived in the same home and I worked at the same job for 5 years.
Well, they brought an action against you.
And I had never heard anything about that one in Douglas County. Nothing was ever brought to my attention.
How is it, though, that you think that, and you just acknowledged that the bills over a 3-year divorce,
You know, Mr. Becker, I really don't think that this is relevant. I mean, you know, undoubtedly, the judgment was a judgment. And, you know, whether, you know, there's some moral obligation or whatever here, questions to me simply is there a basis to extend this thing beyond 20 years? And And one thing that I wonder about as I look at this thing is, I'm not sure that I even have jurisdiction. Because the amount being claimed here, now is like $9,000 or something like that. Of course, my jurisdiction is limited to $5,000.
Right. And I think that the plaintiff's written argument that she submitted to the court addresses that, Your Honor, that the underlying judgment is the $3,138. That's the judgment that's being renewed. Any interest over the top of that would be not subject to the small
I'll take a
claims
look at that,
jurisdiction.
and, we'll also take a look at, what the bases are for extending a judgment.
Right.
I'm not trying to be
Well, and
too
again,
hardcore here, but.
this is my response, I guess. I think the law is the law. Is there a judgment? Has it been paid? If not, are we within the 20-year period? End of discussion. I don't know that it goes into what the court is suggesting that it's going into, that you need to look at the efforts of the plaintiff in collecting that debt. If the court believes that's the case, I would think that the plaintiff then has a right to ask the defendant, what did you do to avoid the debt? And knowing that there was a debt, you choose to put your head in the sand, argue a divorce, and then say now, well, I still don't think I should have to pay that debt. I think that gate swings both ways.
Well,
So I have a question then. When my husband and I, we had a real estate property in Ida County, and we lived there, we lived there together for probably 6-7 years, and no judgment or anything was put against that property. And that property sold in 2005. But now they want to put the judgment against my real estate.
well, the judgment is
now.
the judgment, it's
Right.
it's a judgment, and,
Or if I just have one follow-up question here.
sure.
Who's Maxine Bauer?
That's my mother-in-law, ex-mother-in-law.
I see.
They co-signed the house for us.
Yeah.
I'm not-
I don't have an
I'm not sure what the law is, Bruce, but I have a suspicion that that the extension is really kind of, as I have termed it, kind of an extraordinary remedy, because, the legislature has basically said, you got 20 years to try to collect this thing, and, you need to get it done. In this case, it does not appear that she was hiding. It doesn't really appear that, she was working for cash or anything like that. And, I don't know if Jessica wants to, I've looked at this argument, but it doesn't really address, what grounds are. Maybe there don't have to be grounds, maybe I'm wrong about that.
That's my interpretation on it, that it's basically time-based, and has it been paid? And if not, but the court can review the code section and the cases that she sets out, but I think the court will find
Yeah,
that.
I'm probably gonna go beyond those cases and see what, what bases, have been cited as reasons. And like I said, maybe there don't have to be any reasons. Maybe it's just simply a matter of, we can sit back and, not really do much to collect it, which in this case, I don't think they really did do much. I think probably, if Hamilton told them that it was gonna be paid, I just had another one of those the other day, and, they told Loring or somebody that they were gonna be paid, and they didn't pay them, But there is a lien section in the code that says if you, if you've got a judgment, you can file a lien on those proceeds, and then obviously it does have to be paid. So, I'm gonna learn something here. Have you done this?
Have not.
Yes. First time it's ever come before me.
And I've not done it before either. Jessica Knoll obviously has numerous times, and that's why she submitted the argument.
I understand the argument. And I'm just not sure what the law is, if it's deemed an extraordinary remedy, which to me, would make a lot of sense that, this person was working for cash, every time I tried to collect, they quit their job and moved and that type of thing. We've both seen that over the years. But in this case, it doesn't look like she was doing anything to be evasive, and it's hard to understand how title to the Ida County property.
Other than not paying the bill. It seems evasive enough to me, when goods and services have been rendered and received.
Now, there's a difference whether you owe it, and there's a difference whether and as I understand it, she's saying, I never heard anything when they filed it in Nebraska, which usually when you render a judgment, when you record a judgment, you serve the defendant with a copy, in order to make it even a valid lien there. It's been my experience, at least. And, anyway,
Okay.
the record is made, and if Jessica wants to file any additional, written authority as far as what the, whether it's just simply a perfunctory thing on my part where I'm not supposed to make any findings or anything like that, or, that there has to be some kind of cause other than it just isn't paid.
I'll call her today. And
Yeah, why don't you tell her if she's got anything like that?
10 days,
Yeah, she can just do it in letter form or whatever.
address to the court.
Yeah,
10 days you'll give her?
yeah.
All right, thank you.
And I'll do an order right now, just saying that I'm taking her under advisement, that she has 10 days
All
to
right.
submit any supplemental materials she wants to submit. And if not, then I'm probably gonna try to figure out whether there's any law under that code section that
I will call her.
gives me guidance.
All right.
Just try to do the right thing.
I understand.
Try to follow the law.
Thank you.
Yeah.